see you, and the session hopefully will be interactive. It's been better face to face. But just by way of introduction, then, my name's David Amos. I'm an associate professor in the City Law School, which is part of the University of London. The City Law School has had quite a long history of providing vocational legal education, and a big part of that in England is the teaching of legal skills. And what I'm going to try to do in this session is draw on some of the things that we would do when we were teaching interviewing to our own students, and hopefully find that useful, even if you have already got experience of interviewing yourself. So, the various sections to today's session, I'm going to start by going through the slides that you've been sent by Rory. I should say that I noticed a couple of minor typos, but nothing of any great substance, so I've made a couple of amendments. It's mainly going to be a practical introduction to the skill of interviewing. I am along the way going to say something about the SRA Code of Conduct for Solicitors. That's the ethical code which governs the behaviour of solicitors. There's been changes to that recently which would impact on what you say and do in an interview. So I'll go through those elements in a minute. And then I'm hoping to get you to prepare for an interview for the scenario that you've been sent. I'm going to play the clients, and what I'm going to do is split you into groups so that you will fire questions at me about the scenario and get a bit more information. The advice side of it will be relatively brief tonight, because the scenario that you can go through is going to form the basis of a writing exercise that you will do and submit to Steve, Rory and Will, so that they can have a look at it. I should say that although it's largely going to be me for the first part of the session, I'm going to try and build in a bit of interactivity. So I'm going to try to get you involved by asking you to answer some questions. And I think you should be familiar with the chat facility. And so we'll use that rather than getting people to call out through the screen. So actually, I want to start, and this is, just bear with me on the technology for this. I actually want to ask you a couple of questions, first of all, which is, why would you interview, and what are you hoping to achieve by interviewing? Now, I'll see if I can come out the slides and interact with the chat facility whilst you're answering questions. So if you can type in any answers to why you interview and what you want to achieve, and I'll tap into those. Okay.
Okay. Hello, Ivana speaking. Do you hear me?
Yes, I do. Yeah.
Okay, so maybe because you just need to obtain more detailed information, because you want to know, you want to create a plan. So you just need to get the information from different point of views. That's why the interview is very important.
Okay.
Because
so
you would like to think about the past, the way, as a solicitor, what you want to say in the card, what you want to advise your client, what kind of provisions to use, what kind of opinion to give.
Right. Okay, good. So, and I've got a couple of answers here. That's very helpful. Thank you, Ivana. And we've also got, okay, get more details about possible liability, okay, to achieve appropriate information. So really a large part of it is information gathering, and you can use that then to make some assessment of the legal basis for the claim. Now, this is an interesting one, to check if the client is telling the truth about their case. That is an interesting one, because one of the things that you would use your interview for is to establish a relationship and establish the credibility of the client. Now, you can't doubt the good faith of your client, but you would make an assessment of, particularly in a litigation matter, whether they are somebody who would actually be a good witness, for example. Find the essential elements to establish if we have a case. Yeah. Okay. Good. So we've got some useful ones there. If I just go back to my PowerPoint now, okay, and just a few other things that I want to say. We talked about information. The other thing that we would want to establish is, what is it that the client wants out of the case that they want to pursue? What's the nature of the problem? Do we fully understand it? And we would then use that information to explore a course of action. And somebody mentioned about advising the client what we would do and what realistically we could do. What do we hope to achieve? Well, I've talked a bit about understanding. One of the things that I think is quite important, particularly in initial interview, is to manage the client's expectations, so that they know what is or isn't realistic, how much it's going to cost, etc. The other thing is really about the personal relationship with the client. One of the key things that you need as a lawyer is a relationship of trust with your client. I'll talk a little bit more about that in a minute. And you establish that in various different ways. You also need to, because the client is at the center of everything you do, you need to be responsive to their particular needs and requirements. And again, when I look at the code of conduct, I'll say a little bit about that. So some of what I've said is captured in this rather lengthy quote, which you can read at your leisure, from Mormon Webb. Now, the book that I've referred to here is quite useful text on legal skills. It's mainly geared towards undergraduates, but useful nonetheless. Some key points from the quote. Firstly, which we talked about, information gathering. You can't do anything without knowing what your client's case is, and we'll talk about techniques for how you get that information later. The second thing, dealing with the legal problem, and obviously the reason the client has come to see you is for your expertise. Thirdly, and I think this is an important one, responding appropriately to the person. And they talk in this quote about the relationship being both professional and personal. And I used to, for example, practice as a litigation lawyer, and cases that I pursued could take 2 to 3 years. And in order for me to be able to properly represent the client, I needed to have that really strong relationship with my client, so that I could share information with them throughout the case. And so you need to establish quite a strong bond of trust and confidence with your client. And the interview is a really key part of that, especially the initial interview. So a number of factors that you would take into account when deciding how to deal with your client in an interview to help you establish the relationship. Firstly, the type of interview. Now, we'll look at initial interviews in a minute, and there's a lot more you might cover there than in later discussions with your client. Partly because in the initial interview, what you're doing is laying down some ground rules for how the relationship works. The other determining factor, which is obvious, I think, is the type of client. So are you dealing with the private individual or business client? You're likely to be dealing with those sort of people in quite a different way. And that's reflected in this last point on the slide about what they call one-shotters, or Mark Gallanter called one-shotters and repeat players. Now, one-shotters is generally speaking, a private client who will only go to see a lawyer once or twice in their life. Say, for example, they buy a house and they make a will. Those are the only occasions on which they might go to see a lawyer. And so they're not necessarily familiar with the law, the process of dealing with a client, a lawyer, or legal jargon. whereas repeat players were people who will use lawyers on a regular basis and have a more sophisticated understanding of the law and how it works. And they will treat a lawyer differently, or the lawyer will treat those different clients differently. With the one-shotter, the person who doesn't know a lot about the law, inevitably, because of the knowledge and skill that the lawyer has, they are in a the lawyer is in a more powerful position. And part of the reason behind the ethical code of conduct is to ensure that lawyers don't abuse that position. But it also affects the way you might communicate with a client, of course. On the other hand, repeat player who has the knowledge of the law, and if they're a business client, has some economic power, their relationship with the lawyer might be quite different. They might actually be in a position of some power over the lawyer, because the lawyer loses that client. That's a lot of fees going out of the door. So again, you might treat that relationship quite differently. Now, so the nature of the client affects the relationship you have with them and who makes the decisions. And one of my colleagues, so I do some teaching with Andy Boone, in his book, he's sketched out various different models which I think are quite useful when thinking about how you actually might deal with the client. So the first is a sort of paternalistic, fatherly or parental relationship where the lawyer has the knowledge and skills. And so after the initial interview, they make the decision because they're the person with the expertise. And that's very much a sort of traditional view of how a lawyer might operate. In terms, what you tend to find nowadays is more of a participatory model, where the lawyer provides knowledge and understanding to the client so that they can take part in the decision-making process. In this sort of relationship, neither side will dominate the relationship. Instead, it's more collaborative. And there is some research to suggest that that sort of approach helps you achieve higher settlements in certain types of cases. The autonomy model really reflects, certainly in England, the sort of idea of a sort of liberal democracy, the right of the citizen to make their own choices about life, and the idea of consumer choice. So here, the client will make the choice and the lawyer will implement it. And actually, for a business relationship, that quite often is what the relationship will be like. And the last model is empowerment. Here, the clients are encouraged to take action themselves with support and advice from the lawyer. And that's actually a process that's been very much facilitated by the use of new technology. And so nowadays, certainly in England and Wales, you have this phenomenon of what's called unbundling legal services. So what that means is the client can use tools that are available via the internet to pursue parts of the case themselves, and then we'll just go to the lawyer to deal with the more difficult elements of it. So you see the type of relationship you have will determine how you treat a client. Now, on a more practical note, there are certain requirements imposed on lawyers through a code of conduct, and I said I'd say a little bit about this at the beginning of the session. And the requirements of the code of conduct will affect the way that you manage the relationship. And the reason I'm saying a little bit about these is because in some of the sources that I'm going to give you, they refer to the older code of conduct. There's been a change, or there was a change in November last year to a new code, which is much less detailed, but has retained some of the core matters which determine how you deal with the client. And the code essentially is split up into a set of core principles, 7 core principles, and then there are actually 2 codes, one for firms, one for individual solicitors. So all the references here are to the code in relation to individual solicitors. So the starting point in terms of your relationship to your client is principle 7. You have to act in the best interest of your client, and in most jurisdictions you would have a similar requirement, I think. And then there are a number of elements within the code that reinforce that central duty of loyalty to the client. So paragraph 3.4, you match what you do to the individual client's needs, okay? To some extent that reflects the position under equalities legislation. But at a deeper level, the important thing is about knowing the client, their individual needs, and keeping those at the heart of your action. In paragraph 6, it deals with two important matters which you would mention to the client in the initial interview. Firstly, conflicts of interest. You can't act for a client if there's a conflict between you and them. And if there's a conflict between one client and another client, you can only act in very specific circumstances. And before any interview, or at the first initial interview, you would carry out what's called a conflict check to make sure you're not infringing that part of the code of conduct. The other thing that you would bear in mind is the idea of confidentiality. And that means essentially you have a general duty to keep the affairs of current and former clients confidential. Again, that's something you would probably let the client know about in the initial interview, because it begins to engender that feeling of trust in you, that they can tell you things and nobody else will know about them. Okay. The other thing, rather curiously, you have to deal with right at the beginning, is to to advise the client of their right to complain. And normally, most firms will have what's called a client care partner and a well-defined complaints procedure, and you have to give the clients the details of that right at the very beginning and reinforce that in your client care letter, your rules of engagement letter. You should also, at the same time, advise the client of the right to complain to what's called the Legal Ombudsman if they can't resolve their complaint internally. The Legal Ombudsman is an independent third party who has the power to investigate complaints the way you've dealt with them and impose sanctions on a firm if they haven't dealt with them appropriately. And the last of the conduct matters that I want to talk to you about is firstly about information. This is really crucial for the way that you interview a client. You need to give, you'll see the first sentence, you give clients information in a way they can understand. So you need to give them enough information, and you need to do it in a way that they will be able to work with, because they need to make an informed decision about their case. The other thing, of course, that you do have to be very clear about right at the very beginning is the potential costs, because they need to determine whether it's worth them proceeding with the case or not. So that's all information that you would be required to deal with as relationship with your client develops. And generally speaking, what you would do is introduce that information at the beginning of the case in the initial interview, and then in a subsequent client care letter. Okay, so what I want to do just quickly then, just again using the chat facility, is just the first question, because what an interview should cover will form a lot of what I'm going to say from now on. So you're coming up to an interview with a client. Just a couple of things. What sort of things should you do to prepare for that interview? So again, if you've got any points about that, we'll run through them. Okay, just escape from this and go on to, yeah. So again, if there's anything that you want to say about preparation for the interview, this is. Bear in mind that one of the things that you want to do is to engender trust in your ability. So what do you do in order to prepare for an interview? Okay. Read the case file. Yes, exactly. The collective to know the case will be dealt with by a solicitor. Yeah. Okay, good. Yeah, actually, yeah. I'm not going to sort of labour that, but I think the first point that Ivana and the point that is it Yuri said? Okay, okay, is a very important, really, to be honest, because sorry, I just missed on there. Do some research. Yes. Okay. Yeah. Exactly. Because and this is the case with any of the skills. Some people are naturally better at skills than others, but essentially a lot of skill is about preparation, and the key thing is about knowing your ground. So if you have a case file, make sure you're familiar with the file, because the client's not going to be very impressed when they come in and you don't know anything about their case and you're asking them questions which they've already given you the answers to. But if you don't know, if it's an initial interview, you won't have a case file. So what you will have to do is to do the research and various different elements to that. So research the client, if you can, research the law, and of course we've just talked about conflict of interest. So once you've done that research, what you would then do is to prepare a sort of checklist, either physically or in your mind, of the sort of issues that you needed to go through. Now, we'll see when we talk about the skills involved in an interview, you need to be a bit flexible about how you use that checklist, but you would at least have in your mind what it is that you want to achieve. So, so what should an interview cover? What I'm going to do now is to have a look at some documents that have been produced by the Law Society. They're quite useful, quite practical things. I've sent copies over to Rory so you can see them, but I'll go through the sort of key elements of them. And the first is a practice note, which is, if you like, an advisory note that the Law Society has produced, outlining what sort of things you might do in an initial interview. And on this first slide, you'll see that there are a number of regulatory issues, some of which I've already referred to, that you would cover. So I've already talked about conflict of interest. In terms of identity information. Hello? Sorry. Yeah, in terms of identity information, you are required by law under the money laundering regulations in England and Wales to carry out what they call customer due diligence. So you need to check your client's probity. Somebody mentioned that at the very beginning. So you do need to carry out customer due diligence. So for a private client, that would be something like just getting details of their identity. For a business client, that might be doing a company search or whatever. So you need to carry out those sort of searches. With the initial information, what the Law Society are referring to there is, that there are certain pieces of information that you will have to provide to your client. So what you can do in advance of the interview is prepare a document which you give to your client. You get them to sign it in the interview so that they acknowledge that they know that they acknowledge that you've given them the key information. And that refers back to things like complaints, the name and status of the person dealing with the case, and also costs. So you can have that ready, or you can send it to them later in your client care letter. And also the duty of confidentiality. Okay. Now, with the interview that we're going to do later, I don't need you to deal with those side of things. I'm just flagging them up because you would need to be aware of them. And I suspect in Poland, you've got a similar sort of system. The other things that the other thing that's covered in the practice note and also in a couple of the other notes that you're going to be sent is what sort of things you might want to cover. And these are all pretty obvious. Firstly, and I mentioned it earlier, is about establishing what your client's objectives are, because that's going to determine how you deal with your case. And as I said before, you need to determine whether those are realistic or not. Okay. You should discuss your role. Now, if it's a sophisticated client, they probably won't need you to say very much. But if it's somebody who's not used to dealing with lawyers on an ongoing basis, work can be. Obviously, your advice, we'll keep that relatively limited here. Costs, obviously. A couple of other things that you would talk about, timeframes. And again, that's a big part of managing expectations. Most clients, whoever they are, will want things done really quickly. And if that's not possible, perhaps because of court rules or the attitude of the other side or whatever, you need to prepare them for that possibility. And then communication. You need to establish good lines of communication if you're to properly act for your client throughout. And as I said earlier, you have cases that last for years. You might need information very quickly to provide to the court. So a good line of communication is very important. Okay. So those are things that you might cover, and we'll talk towards the end about how you might structure all that in the way that you conduct the interview. But I want to say a little bit about some of the practical skills that you need in an interview. Okay. The first thing is obviously questioning techniques. How are you going to probe and clarify your client's story so that you get all the information that you need? And that would establish that information thing is very key. So a couple of types of, or two main types of question. Firstly, you have an open question. Okay, so that's something like, what happened? How did it happen? Why did it happen? And they're open questions because they encourage the client to talk. They're not yes or no questions, they're open questions allowing the client to talk. And you probably would use these at the start of the interview so that you can get the general picture of what's happened. Okay, then you have closed questions, yes or no questions. Did they do this? Did you do that? So that you're using those sort of questions to clarify and recap on the information that you've received. Okay. You can sometimes use what's called hypothetical questions. Those are the sort of what ifs. What if this happened? What if that happened? And you can use those to explore the options that your client may have. And you can use those perhaps as part of the advice that you give to the client. You should try to keep it simple, though. One problem is asking a lot of questions at once. So try one question at a time. Don't use multiple questions, and don't make statements. The interview is about the client, certainly part of the interview is about the client telling you about their situation. Okay, so do bear that in mind in the way that you deal with it. And the last thing, I've kind of alluded to this already, is a technique that's called funneling, which is at the start of the interview, you have the open questions and you allow the client to talk. Then as the interview progresses and you've analysed the information that they've given you and you start to get down to the information that you really need, you use more closed questions and you're more directive about what happens in the interview so that you can winnow it down to the sort of things that you need to know. Okay, so that's questioning, but as important as questioning is listening to the answers that you get from the clients. So try to listen what they call actively. So if the client says something, think about how that matches the legal framework that you've put into place. Your research has suggested is relevant here. And this is a certain amount of flexibility comes in because it may be that they're taking you down a entirely different route. But if they do so, listen to what they say, follow up on any lines of inquiry, and if necessary, summarize what they've told you so you can ensure that you've got your understanding correct of what it is that they're going to say. More generally, active listening allows you to pick up on the client's concerns. And they may be legal as well as non-legal. Okay. There are occasions in which, though, you sometimes just have to listen and stay silent. And I'll give you an example, and it's comes from my own practice. I acted for a woman once who worked in a home for young people, and there was a particularly disturbed individual in this home, and one night she was working on her own, and he took a snooker cue and attacked her very viciously, and to the extent that she thought she was going to die. And then, fortunately, she was rescued from the situation. And then several months later, I interviewed her about this. And I knew when I interviewed her that she was only going to tell me this story once. She wasn't going to tell me again. So all of this stuff about questioning, etc., I just said what happened. She told me what happened, and I listened throughout the interview and took notes throughout the interview. So sometimes it's passive listening, and it's important to understand when you have to stay silent and when you have to intervene. Okay. The last thing, of course, is about advising. Okay, and this is what the client has come to you for. This kind of relates back to what I said earlier about how you deal with client relationships. Essentially, I think really what you have to do when you're advising is run through the options with your clients so that they can make an informed decision. And as I hinted at earlier, think about the legal and non-legal options. You need to recognize the context that the client lives in, and sometimes going to law might not be the best option for them. So consider that when you're thinking about the advice that you give them. So once you've established your client's objectives and the facts, as we said earlier, give them a realistic appraisal of whether they can get what they want and the likely cost of doing so. But crucially, in terms of advising, make sure that the client understands your advice. So one of the things that you should try to do is to avoid using unnecessary legal terms. Sometimes you can't avoid it, but as far as you can, avoid using legal terms, or if you do use legal terms, explain them in a way that the client would understand. And sometimes I think of my family members, how would I explain this to them? Okay. And you can ask the client just to repeat or talk through with them the advice just to make sure that they fully understand it. And you should also always send a letter confirming what you said to the client after the interview, but we'll look at writing tomorrow. Okay. So those are the skills that you would need, or the main skills that you would need in conducting an interview. So how do you actually deploy these skills in practice? Every interview will be different, and I gave you an example already of an interview that I conducted in quite a different way to this. But I've sketched out what a standard interview might look like. At the beginning, particularly an initial interview, remember we're using opening questions and we're listening to what the client is saying. Okay, so you'll see there the dynamic is mainly from the client to the lawyer at that particular point of the interview. Then you will start analysing the information and probing the client so that you get everything you need from them. And here, that's where your questioning skills come in, okay? And there'll be an interplay between you and the client as to how things are going and what the information is that you need. Then once you've got as much information as you can, you then go on to the advising. And this is very much where the lawyer is taking charge of the interview, because it's the point at which their skill and expertise comes into play. So that's how, if you like, the interview might flow. Quite often when you'll see quite often in terms of how you might structure an interview, this sort of what they call the Wasp model. Okay, welcome, acquire information, supply information, and advise, and then part. Okay, and this is used quite widely. So the welcome thing, and I'm going to give you a little bit more detail on this in a minute. Welcome thing is what we call, if you like, the meet, seat, and greet. So that's where you're getting the client in, getting them settled in. But also in that welcome phase, what you would do is you would set out the framework for the rest of the interview. We sometimes call it signposting. So I'm going to do this, this, and this. Okay, during the interview. And you can also use that part of the interview to help establish how the relationship will run in a long term. Then in terms of acquiring information, this is the listening and questioning segment of the interview, okay? And then we get on to, once we've listened and questioned and clarified our story, supply information and advice. So where you're using your knowledge, legal knowledge, to assist the client. And then finally, the parting phase. Here, what you want to ask any more questions that they may have, if there's anything they need clarifying, and then you'll agree what plan or course of action, what the plan or the course of action will be from now on. So that's when you'll agree, if you like, the next steps. Okay. Now, I'm nearly at the end of the presentation because I want the main part, the next part of the session. I want to spend as much time as you can on preparing for the interview and then conducting the interview. What I have done in the last few slides is to put in an adapted version of the criteria that we use when we're assessing our students on interviewing. Okay, I won't go through them in a lot of detail because they're there and you can read them. But why I've put them in is because I think they're quite a useful guide to action, if you like, for how you might deal with the different stages of the process. Okay, yeah. So there are certain sort of key themes, and I've just to reinforce what I said already. So in the welcome phase, it is very much that thing about putting the client at ease, getting them to know you, but also dealing with all the client care, the regulatory information that I talked to you about earlier on, and it's required by the code of conduct that you have to cover. Then in terms of the acquiring information side, remember what I said. So listing the client story with opening questions or helpful silence. So it's questioning, silence, listening actively, and it's helping also to establish the relationship with your client. Remember, first impressions are very important. If you establish a productive relationship with your client at this early phase, it will very much help you at the later stages of the case. Okay. Then the supplying information and advising. This is where your legal knowledge will come into play. So analysing what's relevant, what's not relevant, what the options are for the client, and making sure that the client understands it. Now, you'll see here that one of the things we've said is ensuring the final decision rests with the client. So you need to get a clear decision from your client, whether they want to instruct you, what they want to do about your case, and then you can, on that basis, start to proceed to the next phase, which is planning out what you're going to do next, the parting side of things. So make sure that at the end of the interview, the client has been given the chance to clarify everything they need to clarify, and that you understand what you're both going to do, and that you have a mutual plan of action from now on in terms of how you're going to pursue the case. And that will involve certain preliminary elements in terms of follow-up action, but most importantly, it would also involve a plan in terms of the sort of steps that you're going to take from that. And how you got what's called pre-action protocols, which determine operate to, which is that there's movement and that you're taking on their case and you're taking it seriously and you're looking to progress it. Okay.
David?
Yeah? Would
you mind repeating what you said in the last minute, because you got cut off there?
Oh, did I? Okay. Yeah. Where did I get cut off then, Rory? Was I imparting?
Yeah.
So had I done the supplying information and advising?
Yeah, that was all fine. It was literally about 30 seconds ago.
Oh, right. Okay. So really what I was saying in terms of the last bit was that, and I'm sorry I got cut off. For some reason, the connection doesn't seem to be so good today. So what I was saying with this last element was that at the last part of the interview, the client can ask any final questions that they may want to do, and clarify anything that they want to clarify. And then you reach a mutual understanding as to what it is that's going to happen now, and you agree a plan of action. And that plan of action, there'll be some initial steps in terms of confirmatory letters, etc., etc. But then you might also sketch out the timescales for what's going to happen from now on. Now, in certain types of cases, civil, they have what's called pre-action protocols, which determine the timescales. You go through those with your clients so that they know what's going to happen. Because the key thing, I think, is they come to you for legal advice. They're happy with you to take their case on, but what they want to know and they need to know is that there is going to be progress from now on, which is going to be positive and of their objectives, really. Okay. So, one last thing, which is the last thing, do make sure that you keep a proper record of what the client has said to you. It looks terrible if you have to go back to the client for information that you already asked them about. Okay, so that's all I wanted to say in terms of a sort of general introduction to interviewing. That gives us quite a bit of time now to do two things. Firstly, for you to be split up into your groups and to start to plan or to plan out how you're going to conduct this interview with your client, the information that you've been sent around already. So it's a case involving, I'm just trying to get the details up here, but you should all have those in details with you. And what I want you to do is to set up into your groups, think of questions you're going to ask to get the information that you need in relation to the scenario to be able to properly advise your client. Okay. So Rory, are you okay to split people up into groups now?
Yes. Shall I start?
Okay.
Does everyone have instructions on what they need to do before I break them up?
They should do. That was just
Okay. Yep. So am I good to go?
Yeah. So okay, we'll give you about 15-20 minutes to prepare for the interview, and then we'll conduct the interview, and I'll give you some feedback at the end about it. Okay.
Okay.
Oh, do you want me to join the breakout group?
There are some people that weren't pre-assigned, so I'm just putting them into groups right now. So that'll be done in a couple of seconds.
Okay. I didn't quite catch that.
I think you're married, I think. Have you got, do you have a